How jurisdiction applies to the Fdcpa and foreclosure. Brought to you by yourlegallegup.com. Your advantage if you're being sued by debt collectors. If someone is trying to take away your house for non-payment of some debt, the Fair Debt Collection Practices Act, Fdcpa, may or may not be useful to you. After this video, you should know how to give yourself the best chance you can have. Jurisdiction is the court system that has authority to hear your case. The law differs according to jurisdiction, and you will want to choose the one that gives you your best chance. This video is a very basic primer on the interaction of state and federal jurisdictions when it comes to debt collection generally and foreclosure more specifically. Wherever you live, you will want to consider both federal and state cases on applying the Fdcpa to foreclosure if you want to sue a debt collector for its acts in taking or trying to take away your house. If you're trying to stop the foreclosure, you have to consider this question immediately. They won't give you much time. Most debtor-creditor and property law is state law. In theory, federal law only applies to areas of the law designated by the Constitution, whereas everything else is controlled by state law. That's the theory, and it can lead to confusing results where those interests overlap, and debt collection, that is often. In general, the laws creating and enforcing property rights, e.g. contract rights, debt, or property ownership rights, are state law. If you get sued for a debt, the action will almost certainly occur in a state as opposed to federal court. Foreclosure rights are also determined by state law. The Fdcpa is a special situation. Claims under the Fdcpa can be brought in either state or federal court. While property law rights are creatures of state law, debt collection was considered so extensive a problem that it was a national, i.e. federal problem. Thus, Congress carved out a piece of debtor-creditor law for itself when it enacted the Fair Debt Collection Practices Act, which makes certain actions taken by primarily debt collectors illegal. The Fdcpa is federal law, in other words. But, as it happens, it can be enforced in either federal or state courts. Because of the way the federal and state law systems mesh, you could conceivably defend a collection action or foreclosure in state court by filing a counterclaim and seeking an injunction, by filing a separate action in state court under the Fdcpa and seeking an injunction, or by filing a federal claim under the Fdcpa and seeking an injunction in federal court. Likewise, you could defend or settle a state collection action and then bring suit under the Fdcpa in federal court, although remember that the Fdcpa has a 1-year statute of limitations. All of these variations occur quite often. States are independent of each other. The state law of the court in which the suit is brought will always determine some of the procedures in the case, and usually the actual substantive rights. Under certain circumstances, other state laws might also apply, and this comes up most frequently where there's a contract that specifies the state's law that will apply. State laws and procedures can be, and often are, different from state to state. If you live in Tennessee, you will be subject to state laws of Tennessee, and these may or may not be very different in some important way than the laws of Pennsylvania, for example, or any other state. If you are pro se, representing yourself, therefore, your first action must be to determine which state laws, and of which states, apply to which parts of your case at the basic debtor-creditor level. What are they trying to get from you, and what laws determine that? In other words, if you're being sued on a credit card debt, is the company suing you under the law of your home state? Or is it suing you under the law of some other state? And what is that law? In foreclosure law, the company will almost always be suing you or foreclosing without suit under the law of your own state. That's because property is generally determined by the state that it resides in. The courts of one state are not bound in any way by the courts of any other state when they are dealing with their own laws, but they are subject to their own courts of appeal and their state supreme courts. And sometimes in certain areas of the law, the U.S. Supreme Court, of course. State courts are generally independent of the federal courts as well, although, as I said, they are sometimes subject to review by the Supreme Court. Things get a little more complicated when it comes to state courts applying other states' laws or federal law. In a general sense, they should determine what the appropriate court applying its own law would do. In reality, there's usually no appeal to those courts, and so the decisions can vary widely. The federal system is similar to the state system, except that eventually all the federal courts answer to the Supreme Court. That is, when the Supreme Court has spoken, all the federal courts are supposed to make decisions which are consistent with what the Supreme Court says or has said. Because cases are always decided on the narrowest set of facts possible, and because there are so many laws and cases, the Supreme Court often will take many years to get around to deciding a given issue. That leaves the lower courts to guess what the Supreme Court would say. One area where that is happening right now regards whether the Fdcpa applies to foreclosure. Eventually, the Supreme Court will decide one way or another, but until that time, the lower courts apply the law as they see fit, sort of. Each federal circuit controls the district courts below. So the federal judicial system is divided into three levels: district courts, where lawsuits are filed and tried, courts of appeal, circuit courts of appeal, and the Supreme Court. These federal courts are all obviously located within states. So you get to choose between federal and state law if you have an Fdcpa claim. Because the federal circuits are independent of each other and the states are independent of one another and the federal courts, different places develop different rules arising out of the same law. And I know I keep saying that courts hold differently and reason differently and come to different conclusions about things. And this is not because they're acting arbitrarily, but that it's really because the whole legal process consists of interpreting things which aren't clear or aren't perfectly clear. And so there are lots of different rational ways of understanding things, and frankly, people reach different conclusions. A perfect example of this would be the way the 3rd, 4th, and 9th federal circuits and all the district courts below them allow Fdcpa claims against foreclosures, whereas the 7th and 11th federal circuits limit those rights. The states also vary from each other and the federal circuits. What all those different decisions mean is that if you are being foreclosed on and think the Fdcpa applies to your case, you need to forum shop. That is, after determining the state laws that apply to the foreclosure itself, your second task must be to determine whether or not your state applies the Fdcpa to foreclosure. If not, then does your federal circuit. You will need to look at the law for each and decide where to bring your claim. You can bring it in either federal or state court, and you should bring it in the jurisdiction that seems most likely to apply the Fdcpa to your foreclosure. Although this isn't necessarily easy to tell, it can make or break your case, and you need to consider the question as a part of your initial strategy so you know whether or not to bring your claim as a counterclaim or instead file suit in federal court. In a foreclosure, you won't have much time to decide. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com